Hello. In today's video, we're going to talk about 5 important things that you should take into account when you're talking about getting a patent or filing a patent application. So the first thing that you should remember is patents, and when you file your patent application and eventually becomes a patent, patents are negative rights. They are not the right to do something. They're the right to exclude others from doing what is claimed in the patent. So that's number one. Patents are negative rights. The second thing you got to keep in mind is that in order to prepare and file a patent application and eventually have it issue as a patent, it takes time. It's at least a minimum of 12 to 18 months between the time you discuss your idea with a patent attorney and the time you have a patent potentially issuing from your idea. Sometimes it could take up to 3 years. The patent office in the past 3 to 4 years has gotten much more efficient in terms of examining your patent application and giving you an office action or giving you a written statement that lets you know whether or not you can have a patent. So the first thing that we talked about is whether or not patent rights are positive or negative rights. The second thing we just mentioned, or I just mentioned, is patents take time. It is not something that happens quickly. For example, a trademark application, you can file it and within 6 to 8 months, you can have your trademark. However, with a patent application, it's going to take a minimum of 12 to 18 months, sometimes even longer, before you know you can have a patent. The third thing I want to mention, and I think it's really important to keep in mind, is that patents are territorial. In other words, if you get a patent filed in the US and issued by the US government, you can only enforce it in the US. Now, there are ways that you can expand your patent into other territories through the Patent Cooperation Treaty and then eventually entering each of the countries. But the bottom line is, when a patent is issued by the US government, you can only enforce it in US territories. You cannot go enforce it in Canada or Mexico, for example. If you want to enforce a patent in those countries, then you have to go file for patent protection in those countries, either directly or through the Patent Cooperation Treaty process, or PCT. The fourth thing I want everyone to be aware of is that there is a difference between writing the details of your invention and claiming your invention. Both have to be in your patent application. It's just important to understand that you can write details about 4 or 5 different ways to implement your idea, but you don't have to claim all 4 or 5 different ways. You can claim what you consider the best mode. And one of the things that we take into account here at Dana Legal Services when we talk about revenue patents, it's exactly that. How do we protect your revenue stream while at the same time protecting your idea? So we want patents that protect your idea or the best way to implement your idea, as well as patents that protect your revenue stream. And when those two are put together, which is through a combination of what you do in the detailed description versus what you do in the claims, then you have a real quality patent that you can later on license or enforce, because there's a direct connection between the idea and the revenue stream. And the last thing I want everyone to know, which is point number 5, is that patents only last 20 years from the original filing date or your priority date. So if you have filed a patent application January 1 of 2010, that patent will last 20 years from the date of filing. So that would be January of 2020. If you filed a patent January 1 of 2021, that patent will last 20 years from the date of filing, which is 2021 plus 20 years, which is 2041. Now remember, this is from the date of filing, not the date your patent issues. So if you take 6 years to get your patent to issue, then you have 14 years of life left to enforce your patent. If you get your patent to issue in 2 years, then you have 18 years of life. And that becomes really important for certain technologies that last a long time. For example, there is technology out there that is more than 20 years old and still being used. However, there's technology that is now 3 years old and is obsolete and it's been replaced by new technology. So the 5 points we mentioned are things you should know about patents. We'd be happy to discuss the details with you. Give us a call. We can help you. Here's our information. Take care.